The fourth iteration of the Data Protection Bill, or the Digital Personal Data Protection Bill 2022, is in the public domain now. The government wants feedback from people before moving ahead and tabling it in the parliament. The bill introduces the concept of fining data owners or data principals for some offences. It also has provision for high penalties on data processors or fiduciaries for offences on their part. The draft bill fills some significant gaps too. For example, it requires data fiduciaries to notify data principals in case of a breach. But what do terms like data principal and data fiduciary mean? Data principal is any individual whose data is being collected, stored, or processed on any digital platform. If the individual has not completed 18 years of age, his parents or lawful guardian would be the data principal. Data fiduciary can be any website, app, or even a small restaurant, which with the consent of data principals, collects and stores their digital personal data. The draft defines data fiduciary as any person who alone or along with other persons determines the purpose and means of processing the personal data. The fiduciary is also responsible for complying with the provisions of the bill in respect of any data processing done by it or by another data processor on its behalf. Imagine if a person shares his data with a website for booking a flight. The person entering the details is the data principal, while the website becomes the data fiduciary. Another term is significant data fiduciary. The central government may notify any data fiduciary or class of data fiduciaries as significant data fiduciary. Significant data fiduciaries have been prescribed additional obligations such as appointing data protection officers and independent data auditor. The criteria for becoming a significant data fiduciary is based on the volume and sensitivity of data, risk of harm to the data principal, potential impact on the sovereignty and integrity of India, risk to electoral democracy or security of the state, and public order, among other things. Last but not least comes consent. A person may process the personal data only following a freely given, specific, informed, and unambiguous indication of the data principal's wishes. It has to be a clear affirmative action that signifies agreement to the processing of her data for the specified purpose. The draft also has a provision where the data principal is deemed to have given consent in exceptional cases like health emergencies, court orders, and investigations by enforcement agencies. On or before requesting consent, a data fiduciary shall give an itemized notice in clear and plain language, containing a description of the personal data sought to be collected and the purpose of processing such personal data.
If you like this video, share it and subscribe to Business Standard. For more news, views and insights, log on to www.business-standard.com. Do also follow us on YouTube, Twitter, Facebook, Instagram, Telegram and LinkedIn.